I need to learn the basics. Vice Chair.
Big wave over there. I met you last week. Thank you very much. And then our new addition to our committee, our legislative counsel, Dave Berry. Dave, thanks so much. We think this is the best committee in the House, but we're a little biased around here. So thank you all very much for all you do. And so we're gonna kick off the 2020 with first of all, Representative Randy Nix and House Bill 893. Yes, sir. Thank you. Absolutely.
It's pretty simple, but I know how a simple bill can be complicated real quick with a few questions, so. Ready? Thank you, Mr. Chairman. I'd like to present House Bill 893. This is really a department bill, and it's a cleanup bill. To give you a little bit of background, we passed House Bill 511 last year, and this bill was to dedicate the fees on solid waste, hazardous waste, various things that had that title, but a lot of it went to the general fund. Now we've got specific trust funds that these fees have to go to, the entire amount that is collected. When we did this, the other fees were already imposed for 10 years. The funds are there. The trust funds are set up to operate for 10 years. In this case, we did not reimpose the hazardous waste management fees. This bill would simply do that. If you look at the bill itself, it would extend that out to 2032. Right now, if we don't do this, these fees would stop being collected effective July the 1st of this year. If we do not do that, the budget impact is about $1 to $2 million annually. So this simply reimposes those fees to coincide with what the other fees were, the solid waste trust funds, and the other funds to make this work. So housekeeping bill, reimpose those fees for a total of 10 years.
Thank you very much. And I do want to recognize we have Representative Bazemore via Zoom. So thank you for joining us there. 22. Yes, sir. Chairman Dickey.
Thank you, Mr. Chairman. Just want to be clear, where do these fees go?
Where?
To what purpose, or the general fund, or to a specific?
No, these will go to that trust fund. You want to, I'll let Sarah give you the specifics on it.
So if you reauthorize these fees, which are basically fees paid by companies that are engaged in managing hazardous waste in the state, if you pass the bill, those fees will be available to be appropriated by y'all to the Hazardous Waste Trust Fund over the next 10 years. And then once they're in the Hazardous Waste Trust Fund, then they pay for cleanup of abandoned sites. They pay for the hazardous waste state permitting program, all of those traditional Hazardous Waste Trust Fund activities.
Thank you. I just wanted everybody to make sure they knew that.
Yes, sir. Very good. I appreciate it. And if you might expand a little bit further on the fees themselves, so give us an example. A company is in this hazardous
Yes.
waste. Just walk us through that as kind of an education. I think it's a proper time to do that.
Sure, I'll be happy to do that. So there are two fees that this bill covers. The first is the hazardous waste management fee. That's a fee that's paid by any company that is engaged in treatment, storage, disposal, or importation of hazardous waste in the state. It depends on, the amount depends on whether they are a small quantity generator or a large quantity generator. And there are specific rules for determining which one of those apply. And then additionally, the statute provides for the fee structure. So if they're a small quantity generator, they pay $115. If they're a large quantity generator, then it's based on the amount that they generate. And that might be as little as $115. And then it goes up from there based on the quantity amount. The hazardous substance fees, there is a specific list in federal law of toxic substances. It's a much smaller list than some of the other hazardous lists of constituents that we look at. But any company that emits or releases any of those substances also pays a fee. And that might be either accidental release, something that would be what we would consider contamination, but it also might be what they're allowed to release according to their permit. So it's not necessarily a sign that anybody has done something wrong. So those are the two fees. The hazardous substance fee is based on the amount that they emit. And again, that's all specified in statute.
Very good. Well, thank you so much. Do I have questions from the committee? Seeing none, I will entertain a motion. I have a move to pass. Do I have a second? Second. All in favor? Say aye. Any opposed? Very good. Thank you very much.
Thank you for coming. Now you see why I brought her.
Oh, we're gonna,
Thank you so much.
I may have been out of order here and didn't grab my sign up sheet. Chairman Nix, we are in a posture that we passed your bill, but I will take some testimony.
Okay.
I apologize.
My name is Neil Herring. I'm a lobbyist for the Georgia chapter of the Sierra Club. I don't object to the passage of the bill, but I worked on 511 for over 10 years and finally got it. And every dedication in that bill was cited by code section in 511. That citation doesn't seem to be repeated in this language. Does it need to be? I mean, $1 to $2 million a year is a significant sum for these purposes. So I just want to make sure that the dedication occurs, because if it goes to annual appropriation, we're right back where we were before we got the constitutional amendment.
Yes, sir. Thank you. We will ask legislative council, but I believe what we're doing is already dedicated and we're simply changing the date. But
Thank you.
Let's check. Yes.
Yeah. Thank you, Mr. Chair. So my understanding of HB 511 from last year is that it doesn't include this, and that's why we're extending the date. But as far as this bill and the four corners of this bill, it does not include the language that HB 511 included to basically circumvent the constitutional language that requires revenues to go back to the general fund. So this bill, even though it is being extended, the funds that are going towards the Hazardous Waste Trust Fund would first need to go back to the general fund and then be reappropriated back into it, the way that most of the trust funds from HB 511 originally operated. So before HB 511's passage, that's the way those trust funds operated. This will continue to operate in that way, not the way that HB 511 provides for the other funds.
Thank you. Ms. Sarah, do you have something to add on that? We'd be happy to hear that.
I just wanted to clarify that this is reauthorization and not dedication. This would require appropriation by the assembly for this to come to the Hazardous Waste Trust Fund.
Very good. Thank you so much. We are going to move on. I'm sorry. Do you have a question?
Well, I was just curious, if you know that it's gonna have to be reappropriated, and that's what you want, you don't care that it's dedicated.
I would leave that up to y'all to determine.
Very good. Thank you. All right. Well, we are going to move to our next item on the agenda, and we will adhere to our committee rules. We'll direct questions through the chair on House Bill 748. 748. Chairman Petrie, we appreciate you today coming to share with us. At this point, we're going to work on educating our committee. And I think we're going to have a hearing on this bill today and see if we can answer some of our questions. So I appreciate you coming, and the floor is yours, sir.
Thank you, Chairman. And yes, as we discussed, this is an opportunity for us to educate and try to get, make everyone aware of what we're trying to do here. Let me begin by just make sure everybody's got the accurate LC 44-1601 is what you should be looking at, the Coastal Marshlands Restoration Act.
Yes, sir.
As it's titled. I'll go through this in a moment, but let me begin by just kind of telling you where this bill comes from. As many of you may know, there are thousands of acres, in spite of the Marshland Protection Act in 1970, there are thousands of acres of marsh in this state that are owned by private individuals because they trace that title back to the crown or to the state. And so in many cases, these individuals have been forced to go through a very lengthy process with the Attorney General's office in this state. And this has been historical over many, many years. There has been a process that is very cumbersome and very expensive, and which, quite frankly, to most people that have been involved in these kinds of proceedings, looks to be intentional to kind of, disallow people to prove that they do indeed have title to these marshlands. And I want to make something very clear here to everyone that is on this committee today. My intention, being a coastal Georgian back to the Revolution, okay, my intention will never be and is not in this measure in any way to allow any kind of development of the marsh. And I hope everyone here knows that, if you know me, and how much I love the Georgia coast. And but I want to make that very clear because sadly and unfortunately, and we've all learned this to be true, oftentimes misinformation is spread, and it tends to spread like wildfire sometimes. So here's what we're trying to do. There are people, whether we like it or not, that still retain title back to King's Grant or to state grants. In many instances, in most instances, I would say, these are marshes that have been altered by man. If you would think of rice plantations, good example. And so the marsh that, naturally exists has been altered. It's been ditched, it's been canaled, it is in parallel and perpendicular lines, which is absolutely unlike the marsh. If any of you have ever spent any time down on the coast in our marshlands. And so there are people that own these tracts of land that would like to be able to use that land in mitigation to put it back into its natural state. It has been altered by man, and they would like to be able to have it restored to its natural state. Well, again, this bill is really about the process. And so this bill doesn't intend in any way to create any new right to ownership of these lands. It is not intended to do anything to change the criteria for whether or not an individual has a King's Grant or a state grant, going back to a governor, for example. It isn't intended to change any of that. The goal of this bill is to simply facilitate a process of determination that is fair to the citizens of this state. Because the process as it currently stands, quite frankly, is not fair. And it begins with it's almost the inverse of what we have normally. We begin believing that what you own, what is your private property, is not yours. And the state is doing all that it can to slow roll and to delay that process. I don't want anyone who does not have a right, to one of these a right of title to one of these pieces of marshland, to have any kind of advantage in making that determination. I don't want them to be hindered either. I just want them to have the rights that we all should have in determining what is ours. Quite frankly, I would prefer that every acre of marshland in this state was only publicly owned, like the overwhelming majority, but that's not the case. That simply doesn't exist today. So I need to be very clear. That is not the situation we have today. There are thousands and thousands of acres that go back to King's Grant, many of which have already been determined and some of which have not. So this bill, and I'll just go through very quickly and try to, that is what I'm trying to deal with, making sure that the people have their rights to be heard and to have an expeditious manner to determine whether or not they own a piece of property. If they do not, fine. But if they do, the full force and power of state government should not be working against private property owners. So let's begin. So this bill begins, if you will, it speaks to some of the things I spoke to earlier. You will see on line 23, it speaks to restoration of coastal marshlands. As I'll show you in a moment here, everything in this bill is encumbered by it must be for conservation purposes. It must be. And by the way, to the members of this committee, I'm willing to do whatever I need to do to change this. As we all know, this is a bill, this is an idea. We have a goal here that I've just explained. If we need to make it better, to be more protective, let's do that. Let's do whatever we have to do to make sure that nothing ever would change what I just described and what I hope is described here fairly as our goal of restoration and conservation. But you'll see on line 23, it talks about restoration of coastal marshland from damage caused by such activities that will enhance the productivity of the nursery, which the coastal marshlands provide for shellfish and other forms of marine life. And it goes on. You'll see on line 30, it mentions again here that portions of our coastal marshlands are currently owned by private parties that can trace their title to a valid Crown grant or a state grant, and that the preservation of such coastal marshlands may not occur unless by the owner of said coastal marshlands. We're trying to allow them to do so. Line 33, real important. This is an attempt to establish a framework, if you'll see there on line 33, to facilitate the identification and preservation or restoration of privately owned coastal marshlands. And it states in here that we believe, if you support this measure, that that is a proper function of state government. On line 42, you'll see a definition of conservation purposes. I have just been speaking with the Department of Natural Resources, which is neutral in this matter, but they've made me aware of some things we can do to maybe improve even more on this language to describe conservation. We want to make sure that anyone who uses this process is committed and cannot work outside of conservation purposes. And I just had Director Haymans and I were just speaking to that. So we're willing to make that as strong as we need to make it. That's line 42 to 46. I would call your attention to an important provision that we need to discuss on line 69. You'll see now this part of this bill is where we're trying to create a process that is different than we've seen in the past. What we've seen in the past is oftentimes people languishing for years and years, spending money all the while trying to establish a title to their land. What we do here is create a framework, as I said earlier, to allow people a real process codified in law for how do you prove this? Whether they prove it or not is none of my business or concern. But if they need to have a process they can depend on for what does it take for me to establish whether or not I have title. So in line 65 through 70 there, you will see it. It actually gives a timeline of 60 days. It presses the Attorney General to work promptly. That 60 days may need to change. I've had some conversation with folks this morning from some interested organizations. By the way, I would want everyone here to know this bill was filed a year ago. I requested everyone to reach out to me. Heard from no one until this morning. Isn't that interesting? We all know how that works. So, but here's the deal. As I said a year ago, any of these measures can change if it ultimately gets us to our goal of creating a fair process for the citizens of this state. The 60 days may not have to be 60 days, but in this bill, it says to the Attorney General, you have 60 days from receipt of the abstract of title, all of this information that the petitioner provides, which outlines what they believe shows concretely their title back to a King's grant or back to a state grant that is received by the Attorney General's office. Herein, we've given them 60 days. And it says here, the Attorney General shall have 60 days from receipt of the abstract of title to provide the petitioner with written certification as to whether or not such petitioner trace the title to the coastal marshlands to a grant. Okay, so that's very important. And that's an issue that I'm welcome to discuss. If you will go on down, you'll see on line 77, this bill states that the petition will be filed in Superior Court of the county in which the marshlands are situated. Okay, that's an important provision I want to point out. I'm trying to go quickly and I'm glad to stand for questions, but I want to hit the important parts here. Line 92, this requires publishing in the legal organ of the county. The action that is intended has to be published for 4 consecutive weeks. And an interesting piece I want to call out in line 99 on down to 105. This creates, in the interest of efficiency, a special master, which is not uncommon in the judicial system to help expedite matters. It creates a special master, and this special master that would be designated by the court would be an individual who is authorized to practice law in the state, demonstrates experience in real property law, and resides in the judicial circuit where the action was filed. And again, we've got a timeline there for how long it should take to appoint that special master. Line 113 through 116, I would call your attention to. This is real important that I emphasize. And I'm going to emphasize it by reading it. And again, we can tweak language and make it better. Any coastal marshlands, exclusive of the uplands contained therein, which are subject to a decree as provided for in this part, shall, not may, shall be restricted to utilization for conservation purposes. Now, again, as I discussed with Director Haymans earlier, if we need to change that definition to make it even better, welcome to do that. But the point, I hope, is well received. Shall be utilized for conservation purposes and for those alone. Provided, however, and this is important, that the uplands contained therein may be used for conservation purposes. So remember, we're beginning with the premise that the uplands are, obviously they're already not marshland. The uplands are by definition not part of the marsh. So it's really not what we're dealing with here. The uplands are not encumbered anyway. So if there's any questions, we can talk about that. It's 113 through 116. 119, Mr. Chairman, I would encourage you to highlight, and this is really what we're trying to do here, the existence of a grant. If there is indeed a valid grant that is determined, that shall create a rebuttable presumption that the state divested itself of any interest in the property to the low water mark. Okay, because they then have proven they have a Crown grant or a state grant. Those are the biggest issues. Again, you'll see on line 132, again, we talk about restricting for use of conservation purposes. So I know I'm kind of repeating myself now, and the bill repeatedly fixates on that because, again, that is the goal here. The goal here is not to do anything that would ever allow any kind of development of marshlands. However, if individuals that are private citizens of this state do have title through the state or through the Crown to marshlands, we want to expedite the approval of that process, give them a process that allows them to without being encumbered inappropriately, prove that. But to follow this process, if it were to be created, it would have to be Loctite for conservation purposes. And so whether it's a rice plantation is a good example of some that exist in my part of the world, or whatever it might be, they would have to be dedicating that land to conservation use or to some kind of restoration, which is, by the way, some of the things that could be, and listen, the state could be doing that now, but they aren't. Okay. I mean, you're talking about enormous projects. So at any rate, Mr. Chairman, I've done the best I can to explain it to the best of my ability. Glad to answer any questions and glad to learn what I can from the committee about anything we can do to improve upon it as well.
Well, thank you very much. May I ask one question?
Yes,
If
sir.
you will walk us through, do you have an example of something where you can kind of walk us through and say, here's, Mr. Smith, and he's trying to do this, and here's the problem. Just
Yes.
kind of give us in a nutshell.
So I'll
We
give you-
understand.
Yeah, I'll give you a couple of examples. Thank you, Mr. Chairman. Good question. So I've heard numerous stories, but I'll give you one. We've got situations where we've had situations where I'm told, and as most of you know, I'm not an attorney and I don't represent anyone who has been in a situation like this. I simply know people and citizens, constituents in some cases, who have been through similar situations like this. So we've had scenarios where when an individual has clear title all the way back to the crown, there is this constant effort to say, well, the document is illegible. Meanwhile, those documents, to any reasonable person, you can read everything on the document, but they have been they languish. It goes on, and it's like every procedure that can be discovered pushes them back further and further and makes it more and more expensive, of course. And so they give up. Another example would be a large tract of an individual that is a former rice plantation, thousands of acres, that an individual would like to use for mitigation products. Any of y'all are familiar with our port in Savannah. They are constantly looking to do mitigation projects because we're constantly altering the Savannah River channel. And so mitigation efforts are required. One of the things we can do in mitigation is to take these marshes that have been, frankly, devastated by man-made impacts,
Mhm.
and we can put them back into their original state. Those projects can't happen, okay, unless someone can prove title back to the king or the state. Now, again, nothing in here is going to make that an easier thing for them to prove.
Mhm.
You either have it or you don't. What we're trying to do is to make it clear that there's a fair process where they can, in a fair and reasonable due process, expedite getting an answer so that it doesn't have to languish for years on end. So in most of these instances, to your question, Chairman, the common denominator has always been a lengthy, drawn out, what is perceived to be intentional process of trying to just establish a clear title to what these people have been paying taxes on for generations.
Very good. Thank you. Members of the committee, are there questions? 16. Yes, ma'am.
Can you tell me how many of these Crown grants there are?
I cannot, Representative, I don't know if, I'm not going to put him on the spot, but I don't know if the director has an answer to that. It looks like he does not either.
Ballpark.
I do not know the ballpark, Mr. Director.
So,
Well, let me say this, but Director, if I can, Mr. Chairman, can I direct
Please.
a question to the Director? So, but Director, we have many of them that are already established, correct? So are you talking about in addition that we may not know about? Because we know we have many of them already established. I just don't know how many, Representative. I have no idea.
may I ask another question?
Oh, please go ahead. Okay.
About the 60-day period. So I'm looking at line 73, and it looks like regardless of the merits of if I'm reading this right, regardless of the merits of the claim, if the Attorney General doesn't issue a certification within the 60-day period, then that's an admission that the petitioner has traced the title to a grant. So it's like a de facto, if the AG misses the misses the time period and can't do this within 60 days, then it's like a de facto King's grant.
Well, all of that would be based on a determination having already been made by the special master. But correct, and all of that can be changed, but here's what we're trying to do. We're trying to force the Attorney General's office to be responsive to the public. That is correct.
Well, I mean, I, having gone through everything we've gone through in COVID and seeing how, unforeseen events can certainly take
Correct.
over. 60 days for something where we're talking about a grant that is centuries old just seems a really, really small period of time to me, because it just seems like these would be such complex grants to actually research. And I don't know, 60 days just seems like a very, very small period of time.
I think that's a fair comment, Representative. And again, as I mentioned, actually, in my initial comments, these are the kinds of things that as we begin with discussion, that I would like feedback on. That's a good point. And so 60 days doesn't have to be 60 days. I think at the end of the day, I think you understand what I'm trying to do is to make sure that we have a process where people know how long it should take. And whether that's 60 days or 90 days or 120 days, it doesn't matter to me. But I certainly understand your point, and I've had several mention that this morning.
Let's get, and then we'll circle back. Chair Lady Smith.
Thank you very much for all your hard work. And this committee's dealt with coastal issues for years, so we appreciate the experts who are willing to come in and help us understand this. Most of us are landlocked. We like the coast. So to understand this process, I guess in the end, I want to ask you, if I get it approved that I had the land grant, therefore I can turn around and use it for mitigation process, which is what is the trigger to make me want to go through this process, I would think. Okay, do I pay taxes? How does that work? I mean, do I own it still and therefore I pay taxes on it? Why would I do it? And then how does it work?
Okay, and Chair Lady, thank you for the question. So first of all, so these individuals they already are paying taxes and have been.
Forever?
Just,
I bet they're afraid
correct.
not to, so.
Yeah, they've been paying taxes for, again, as I said earlier, in many cases, generations. So yes, they would continue to do that. There's nothing that would alter that in this measure that I'm aware of.
So they retain ownership, but like most conservation type programs, they have limited use of but there is a financial incentive to them because it can go into that
Absolutely.
mitigation pool.
Yes, ma'am.
Is that a correct understanding?
That is correct. Yes.
Thank
ma'am.
you, sir.
Yes, ma'am.
Representative Smith.
Thank you, Mr. Chairman.
Number 2.
Smith too, yeah. That's Smith 1 right there. So we'll make sure we get that correct. A couple of things. I know we mentioned mitigation, but if it did come through and you got everything settled and everything was proven, you still got the whole process of mitigation to go through on top of this. So that's another whole process in itself. So, okay. I guess one thing I was looking at, the 60 days that was pointed out earlier, then on line 105, you talk about the special master, and it says that should be made no later than 60 days after the filing of the motion. So we've got 60 and 60. Kind of explain that to me. Are we going to have 60 days to appoint a special master and then another 60 days to get an answer, or?
Yeah, I think, my understanding is that the Attorney General would respond within 60 days. And then the special master would be appointed within 60 days as well.
Okay. So then the definite answer.
But that's
when would it come?
the court. Let me make sure, because I may have misunderstood, but the court is appointing the special master.
Okay.
So this is like in different stages. The
So-
court, once it's assigned to the circuit in which the county resides, then the court is going to have 60 days to appoint a special master.
So it could be that once it's taken up, there's a 60-day period and then they appoint a special master, there's automatically another time period for the special master to make a decision. So we're kind of reaching out there. We don't know exactly when the end is, correct?
That is correct. Yes, sir. Because again, all of the due diligence that is necessary to prove that this is a legitimate claim, nothing is intended to change that part of it. And I think that's where it gets confusing to explain. We want there to be plenty of time for an expert to really make a determination on whether or not there's clear title, trying to make sure that there's just a fair process to do that once you have that. So, and again, Mr. Chairman, I look forward to any input I can to make this better. I'm here this is an initial, drop the bill a year ago, hoping to get feedback from everybody. Really got none from anybody. Anxious now to learn, talked to the chairman earlier, and we agreed that the goal here today is to try to speak about it, not to take a vote on it, but to learn, to educate, and to learn what we can do to make it better. If the will of the committee is that this is a noble cause, which I believe it is, but anything we can do to improve some of these, willing to do.
Thank you.
Thank you.
Representative Buckner.
When you talk about mitigation, there's a lot of different types of mitigation that can occur and be used. One of the ones I'm curious about, because this involves uplands and the marshland, how would this legislation affect, say, our state's carbon registry?
Representative, I don't know how this would affect the state's carbon registry. I do not know the answer to that.
Okay. May
I'm
I
sorry.
follow up with a different question?
Yes, ma'am.
On line 16, you talk about the the Coastal Marshland Restoration Act. Is that defined somewhere already in the code, or will that be defined, say, by the DNR board or legislatively? How will we define that? Because that could be real critical, that definition, in my
Yeah,
thinking.
that is this newly created language would be described herein as Coastal Marshlands Restoration Act. So that is not in current statute.
So we would need a definition of how we are going to define what restoration will occur.
I think that is very fair. And again, we do our best under conservation purposes, as I mentioned earlier, but which certainly speaks to those things. But we're glad to improve upon it in any way necessary.
Thank you.
Representative Williams, did you have a follow-up? Would you like? Sorry, tell me their number again. I apologize.
Thank you, Mr. Chairman. I'm just trying to understand the concept of mitigation projects is new to me. But it sounds like it's a valuable asset. It's something you can sell, like you talked about. You talked about the Savannah River project, and is that something that a corporate entity would want to buy from a property owner?
Yes,
I mean,
Representative.
that's the asset you're
Yes.
creating by doing this.
That's correct. Well, so what exists now is this marsh in many cases, as I described earlier, in a degraded status. As Representative Smith over here, the former chairman of transportation, knows so well, whether it's transportation projects or whether it's maintaining our port, there's often requirements for mitigation. And yes, if the state seeks out where we can mitigate, they need those opportunities for us to do these projects. And so it would allow, to your question, a private individual that would have these marshes to, yes, sell those mitigation credits to improve that marshland. That is correct. And that was the purpose when it was first being discussed with myself and
Right.
others who had gone through this process for years on end.
That's the value of these marshlands right now.
Yes,
Or the
ma'am,
King's
that would be
grants.
the value.
So can you give an example of, I mean, clearly you're familiar with people who've gone through this before. Can you give an example of how much what's the price tag, or I mean, what's of a mitigation project? What's,
No.
I mean, or the range?
Of the mitigation itself, which is a
No,
little bit
no.
outside of this, I can't speak
No, I
to
mean,
that.
what is the value that the owner of the King's Grant would receive for I mean,
And
obviously they are selling this asset.
I
So
think
what-
they would. I think they could, and many might if they had the ability to do so. So I'm sure many have already done so. Again, there's numerous King grants. I'm going to look over it. There's numerous King grants that are already established. The problem here is that it takes a long time to establish them. But to your question, I can't speak to the cost of that or what the value of that marsh would be per acre for mitigation, because in my personal life, I'm a healthcare provider. I know nothing about the value of those mitigation credits. I simply know the value to society of having the ability to use those mitigate helps us to, I mean, we can't maintain our port in this state without mitigation credit, but I can't answer that question.
Yeah,
Representative.
I just
It's a
seems
good
like,
question. I just, can't
I
answer.
guess it seems like the purpose of what's driving this bill is the desire of people who have this property to be able to use it for mitigation grants. So I'm just curious what the value of that is too, because we're talking about meeting the needs of these consumers. I'm just curious about what the
Sure.
value is.
We may
Mr.
have to
Chairman? Oh.
find that offline. We are
Yeah.
definitely on a time limit here.
I
close
just,
to,
can I
1 hour.
respond real quickly?
Sure,
Mr.
yeah,
Chairman?
please.
I just wanted to say to the representative, first of all, I think it's an excellent question. I'd like to know the answer to that as well. But to make it clear on my intent here, my real intention is to make sure that everyone that has a piece of private property has a right to prove that without being encumbered by the power of the state. I think as a fundamental to me, that is fundamental. That is key. What determination is made is none of my business, but there should be a fair process. But thank you for your good question. I hope we all get the answer to that.
One more quickly, sir.
Sir,
Chairman Smith.
just thinking about that question, I would say, in my opinion, that's kind of a market-driven price to Representative Williams, because you have X number of projects at certain times, and there's X amount of land that can be used for mitigation. So it's kind of a market-driven price out there, and that it's hard to put a definite price on what it would be. It could vary.
Thank you. All right, we have 3 groups that would like to comment. Miss Amy, would you mind leading us off? And in interest of time, I think we're going to have 3.5 minutes. We have Health and Human Services coming in right behind us. So.
Good afternoon, everyone.
There we go.
All right. Good afternoon, everyone. My name's Dr. Amy Sharma. I'm the Executive Director of Science for Georgia. Our nonprofit is dedicated to making sure science is used appropriately. And for pragmatic science, we look for evidence-based pivot points that provide high impact. I'm here today to tell you that HB 748 poses a risk to salt marshland as it is written. Salt marshland is a high impact pivot point. It's valuable to the Georgia ecosystem. It punches well above its weight. It filters harmful toxins. It provides valuable carbon sink in reference to your carbon registry. It harbors complex ecosystems, and it buffers against flooding. Salt marshes keep our coastal waterways clean and protect our coastal communities from flooding. Most of the 400,000 acres of salt marsh are owned by the state, as we established, and state ownership enables the public to benefit from this. 748 deals directly with land, and as written, it muddies the water on what restoration and conservation means and the applicability of protections provided by existing statutes. We must ensure that existing protections are not weakened. I am pleased to hear the representative just offered to clean up this language and strengthen it more. Additionally, we heard the only exemption to state ownership is salt marsh King's grants. Okay, that was from the King of England. If the AG's office does not meet a 60-day deadline to certify a King's grant, the grant is by default certified. This math doesn't add up. This time period is unrealistically small, given that we declared independence from England about 250 years ago. And there are a lot of complicated and unusual conditions in many of King's grants. Verifying compliance can and will take a long time. Personally, it took my grandmother years to prove genealogical records for the status of the Daughters of the American Revolution, and that was for tea parties. And this is for like valuable land grants and mitigation credits. Given the small number of people in Georgia who may still actually qualify for these King's grants, the invaluable service public ownership of salt marsh land provides to all of Georgia, and it is unnecessary to limit the AG's office to an unrealistic timetable. So science agrees that protecting, preserving, and restoring salt marshes is invaluable to the citizens of Georgia. Unfortunately, as written, this bill muddies the waters on protections, places an unrealistic burden and time frame on the AG's office, and negatively impacts the greater good of Georgia. Thank you.
Thank you very much. Ms. Peck? Just introduce yourself quickly and who you're with.
Sure. I'm Rena Peck. I'm an ecologist. I'm head of Georgia River Network. We work with the state as kind of the NGO arm to increase river recreation and house the state's water trails network. So our concern is the muddying of the waters, I'll say as well. And with wetland impact mitigation, having land protected before the restoration is key. However, this land is already protected, so you're really not adding value there. There are a couple questions that we could ask, and some of them have already been asked. Again, how many people are out there trying to validate Crown grants? Is really this legislation necessary? Given the importance of Georgia's coastal marshlands, shouldn't we ensure that the proper steps are followed and that we can take the time we need to verify that any Crown grants are still valid? This person's client may have applied for it a year ago and been done. Who knows? Why does this bill involve both uplands and marshlands? And why are uplands included in the definition there? So these are some of the questions that it's important to figure out to close any potential loopholes. It appears that this could also allow for the development of private marsh hammocks and islands. Thank you very much.
Very good. Thank you. Alex with 100 miles is next.
Good afternoon, committee members and chairman. I'm Alex Muir. I'm with 100 Miles, and we are a coastal conservation nonprofit working to preserve and protect our coast through citizen engagement, advocacy, and education. I want to thank Representative Petrie for really going into the details about this bill, because that scares me a lot of, and all of us, a lot of what's on here. Clearly, the more marsh we have along our coast, the better. Nobody is going to argue that. And mitigation banks have huge potential in Georgia, regardless of who's owning them. There's potential, but clearly if it's within the hands of the state, there's a lot more potential for good coming out of that mitigation banking. I just want to be clear that we do see that the due diligence process is changing in this bill if it were to pass, because you are putting a 60-day timeline or deadline on the Attorney General's office's ability to do their due diligence and make sure that it is actually a legitimate claim. Considering the stipulations, like we've heard, that go back to when the king had jurisdiction here, and kind of the oddities of these stipulations, including have you maintained rice cultivation, have you had a member of your family in the military? These sort of things take a while to clarify and to make sure that they're there. If they're not there, this is the state's property. And it needs to be determined legitimately whether or not that actually happened. To Representative Williams' point, this default, giving the applicant their title after just 60 days, which I know Representative Petrie is willing to work with the community on this. It changes the burden of proof. Right now, the individual claiming title has to actually prove that they own it. This de facto 60-day deadline is not really in the best interest of the public. And finally, I just want to say that we're more than happy to work with whoever's wanting to participate in making this bill the strongest that it could be. But clearly, it needs a lot of fixing. It's very ambiguous. We're not sure what it would mean for our state. And we know that these resources are world renowned. And so we can't at this time take a chance of passing anything that would potentially jeopardize that moving forward. And I just want to leave the committee with something to reflect on. These policies of King's grants are very antiquated, and they were based in a time where we had injustice, where a lot of people that are in Georgia today would not have even been considered able to own land. They were barred from owning land. So why would we want to facilitate and expedite this to then have people hand that land over and under what was such an unjust policy at the time? And I understand the need to expedite, but I think to go from years and years to just 60 days is way too much in this instance. So I want to thank y'all for your time. Have a good day.
Thank you very much. And finally, Mr. Skinedge.
Mr. Chairman, members of the committee, thank you very much. I'm here on behalf of Dr. Jerry Williams, who is my client and who also is a landowner on the coast of Georgia. I want to applaud Representative Petrie for bringing this bill, and the problems he has outlined earlier are exactly what has happened to my client. He has title, he contends, we feel has good proof of title from a governor's grant going back to his family many generations. Dr. Williams has paid taxes on this land, including the marsh, for many years, and yet has been locked into a fight with the state over the right to, or the claim to establish title for quite some time. We think this process is needed. Let me boil it down to you very simply. Under this bill, as I understand it, and I believe Representative Petrie will validate this, one of two things happens. If you cannot prove that you have title, then the state has title to the marshlands. If you can prove you have title, you are the owner and you put it into a conservation easement and the marshlands are preserved that way. To me, that is a win-win for the state. Either way, you're going to protect the marshlands. If there's some work to be done to try to repair them, that could be done. But I think either way, the people of Georgia win. So we support this bill very strongly. I look forward to working with Representative Petrie and the members of the committee on the bill, and be glad to answer any questions if there are any.
Very good. Thank you so much. Chairman Petrie, thank you for bringing this bill.
Thank you, Chairman.
I know your heart is in a good spot on this one. We look forward to working with you on it. And point of personal privilege, I would be remiss if I did not thank the chair lady for continuing to allow me this position, and enjoy working on this committee very much, and look forward to the rest of the year. Yes, ma'am.
The chair lady is very interested in keeping you active in that role until you leave. This is my protection act.
Thank you very much. We are adjourned.